The SSC shall follow the rule letter and spirit. Therefore, that rules which was prevailing with the division bench was declaring this law, and that rule was challenged before the Supreme Court. Therefore, all things were that this is 2016 selection.
Where Mr. Bhattacharya, it has been directed that new rule cannot be framed.
What the court says, that you initiate the selection process with declared vacancies which were declared then, not new declaration, number one. And number two, shall follow.
Yes, the declared vacancies
Governing the selection. Which selection?
Yes, rules governing the selection.
Selection.
SSC shall follow the rules governing the selection process immediately. Whatever the rules are there, that is to be followed. That is to be followed. That is to be followed in the next selection process. Now the vacancies. Now tell me, if there are 1600, say if there are 100 vacancies in 2016 selection process for classes 9, 10, 11 and 12. Now in the meantime, if due to creation of certain vacancies, if vacancies are added, this cannot be taken into consideration.
Can I just simple also permit me? Since your lordships have heard Mr. Mitra and Mr. Lordship, if your lordship give me some time, if I can clarify all these points.
I will hear you, Mr. Mondo.
I understand.
I will hear you.
These are the points I've already argued by Mr. Mitra.
No, but this was not a detailed
I
argument.
am not saying
You are not there.
At this stage of motion, there cannot be a detailed argument. If your lordship thinks that detailed argument, the matter is disposed of, I don't mind also. I don't mind also.
Allow me to hear, then I will hear.
I am saying, I am just saying.
I have that on basic paraphrase issue. Therefore, this division bench judgment was declared at point of time. When the division bench said that.
So according to you, Mr. Bhattacharya, first of all, the declared vacancies should be separated, and a selection process is to be initiated in terms of the recruitment rules of 2016.
Because these vacancies would arise because of the cancellation of appointment by the court. If the court permitted you to do it afresh.
Now this order must be the order passed by the Honorable Supreme Court. Kindly come to that order.
Kindly come to order on Supreme Court at page 83.
Paragraph 45 onwards.
Yes. Last question, got it.
Conclusion under
Yes.
the heading conclusion 45.
The last question relates to the relief, which it requires, whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who are appointed must be terminated, and they should be required to refund salaries payments. Since their appointments were the result of fraud, the amounts to cheating, therefore we see no justification to alter. Then 646. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void.
This is for a disabled candidate. 46.
Not specifically found to be tainted.
Yes. Please read.
Selection process has been rightly declared null and void due to the egregious violations of the illegalities, which violates Article 16. As such, the appointments of those candidates are cancelled.
Yes.
However, the candidates who are employed need not be asked to refund or restitute any payments made to them. However, their service will be terminated. Furthermore, no candidates can be appointed once the entire examination process and results have been declared void. Then next week. 43 is not necessary.
Yes, it's not necessary.
Now, kindly come to 48.
48 is also
not necessary. The disabled candidates mentioned is period which.
Yes, it is necessary. Please read 49.
I am reading 49. My juniors will insist to read 48.
Yes, I am also saying it's necessary. Yes, please.
Lastly, we address the case of the disabled candidates. Our attention has been drawn to such cases where impugned judgment had held the appointee so and so shall be allowed to continue on humanitarian grounds.
While paragraph 49 says.
I was in paragraph 48.
48. Yes, paragraph 48.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee so and so and allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed. Then, the disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation.
Not other concessions.
No,
Only age relaxation. But in case of disabled, other concessions and age relaxation.
we are not here troubling the court with disabled candidates. In our opinion, such a direction if fair, it would allow these candidates to take part in fresh selection process, which should now be initiated to fill the vacancies. Therefore, this is now being
Now, I will ask you, Mr. Bhattacharya, where is the bar in framing separate rule?
First of all, I don't say that they have no power to frame rules, but that rules will come prospectively. Here, the declared
No, in terms of the order of the Supreme Court.
Supreme Court always says, Supreme Court passes on at the point of time when the rules are prevalent.
Yes, but Supreme Court did not expressly debar the state authorities or the recruiting authorities from framing rules.
Well, these questions did not arise at all. My lord will have to consider that when court is passing an order, keeping the law as it was then available. And when court found that the appointments or a particular selection is bad, court is permitting to do that selection afresh. If you do that selection afresh, you have to go back to that situation. You cannot come back later and bring something new. That would be really betraying the confidence of the court with the authorities. Therefore, 2016 selection should be made in terms of 2000 selections. That is your submission. That's my submission. And then kindly come to me, Lord. Yes. Accordingly, paragraph 51, we afford the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in the direction issued by the High Court. The appeal at this was so and so. However, we independently take up the issue raised in filed by the state. That's a different issue. Now
come to 17th April order.
Now kindly come to the application filed by them before the Supreme Court.
And 17th April order is German.
MA, kindly come to the MA.
Come to order dated 17th April.
No, order will be necessary. Let us see what are the application made. Kindly takes up the application.
Application, that is miscellaneous application 709.
Yes.
Taken out by the West Bengal Board of Secondary Education.
What was the application for?
Page.
My lord will find that application in the next matter.
Next matter allowed.
Page applications next matter running page 188.
Yes.
So this is the application, also fine. This is the ME. They quote the order of the courts. They kindly come to paragraph 4. They have again quoted the order of the divisional bench.